Hello again. So we're here now to discuss this concept of occupiers liability in the area of tort law. And specifically, this lecture is relating to the material and discussion aligned with Law 1204. So this content is specific to March 27th, okay? Occupiers liability is essentially this concept that somebody who is in control of the land, whether it's the landowner or just the possessor of the land at the time, they're responsible for injuries that occur on their land. So that's what occupiers liability is. Originally, so going far back in history, the courts determined that landowners were essentially kings in their own castle. They could do whatever they wanted on their land, and they should not be liable to any injury that resulted to another individual on their land, because the land was their domain, it was their place. So landowner or an occupier could do almost anything in respect of their land, okay, and act with immunity. So in other words, they could not be liable in tort law for any reason. Over time, there became a growing awareness that, that even if it was the landowners or the possessors, and I'm going to come back to the differentiation between those two, even if it was their land, they still had some kind of responsibility to ensure that people who entered their land were not injured. And so when we talk about somebody coming onto the land in the area of occupiers liability, we call them entrants, but not entrance in the term that you might be familiar with it, an entrance to a door, to a house or to a mall. Entrant, E-N-T-R-A-N-T. So it's spelled slightly differently, okay? So an entrant is somebody who enters the land. So over time, the courts came to find that occupiers did in fact owe a responsibility or a duty of care to entrants or somebody entering the property. So we first look at the concept of common law, and then we come back to what does the current day say? What does the legislation or the statute law suggest about an occupier's liability? Prior to the statute coming to be, we only relied upon court decisions in this area, so case law or common law, and we've talked about what common law is different times. Under the common law, occupier's liability extends to anyone who's in control of the premises. So this concept of control now really gets to that distinction between, are you the landowner or are you just the possessor? A possessor might be somebody who rents the land or rents the space, and maybe they're the ones who are actually in control of the area. So we're not specifically tying liability to the landowner. It could be a possessor, it's whoever has that control. So what does the control, what does that actually mean? Well, the courts identified it as being a question of, does this person have sufficient control over the property or the premises that he ought to realize that a failure on his part to use care may in fact result in injury to another person who is unlawfully on the property. So ownership is not the test, control is the test, all right? The owner might not be liable for any injuries that have resulted in the property. It is the person who is in possession that is likely to be found liable. They are the ones who have more control. What does control actually mean? Determining who can enter the property, regulating and maintaining the property, and determining what kind of activities might take place on the property. If you exercise that right or responsibility over a particular land, then you're the individual who's in control of the land, okay? So there are three types then of people, or three categories of people, I should say, at common law, who could possibly enter somebody's land, and as a result, the person in control might be liable to them for any injury that occurred on the land. So the three categories are trespassers, licensees, and invitees. Now, I have created a pyramid chart for you, and it appears throughout the slides if you've looked through the slides already or are following through with them now. I also created a separate Word document that shows sort of the transition of all of the different pyramid slides through the PowerPoint into one pyramid chart, okay? So essentially that chart is just a visual representation of how liability is attached to each one of those categories of entrance. There is less of a duty or a responsibility that is owed to a trespasser, and the higher up the pyramid, at the top you see the invitee, there is more of a duty or more of a responsibility that is owed to someone who's invited onto the property, okay? So So what is a trespasser then? Let's start at the bottom of the pyramid. A trespasser, you know what the trespasser is, right? More or less. The law defines a trespasser in a very similar way. Anyone who enters the premises without permission or invitation. Because they have no permission to be there, the landowner or the person in possession of the land has a very low duty of care to the trespasser. A low duty of care does not mean no duty of care. It just means a low duty of care. And historically, the courts have determined that to be a duty of common humanity. What does that mean? How would you treat a fellow human being? You have to treat them with some respect and some decency if they're entering your property, even if they weren't invited. There's some dispute over this definition of trespasser at common law because it makes no distinction or differentiation between the trespasser who may be a burglar and the trespasser who might be an innocent child who's entering onto the property. Nevertheless, that's what the concept of duty that is owed to a trespasser is, the duty of common humanity. So on your pyramid, you'll see that at the very bottom. The second category of entrant or class of entrant is a licensee. A licensee is more than a trespasser, but they are less than an invitee, okay? So there's someone who enters the premises with consent of the occupier, but they're not classified as an invitee for a very different reason, and we'll come back to that shortly after we talk about what an invitee is. An example of a licensee might be a cross-country skier. For example, if you're familiar with rural areas where people own acres of land and they allow for a footpath or a cross-country skier just to pass through their unfenced sort of large property, okay? A political candidate who's canvassing might also be considered a licensee. So a higher duty of care is owed to licensees than to trespassers, but not quite as high as as the duty that is owed to an invitee. There is a duty to take reasonable care to protect a licensee from unusual dangers. So a licensee entering the land should expect that there could be usual dangers on there that they don't need to be notified about. But a landowner or someone in control of the land, a possessor of the property, has to point out any unusual dangers. An unusual danger might be that which only the landowner would know of. So for example, if you in fact owned acres and acres of land and property and much of it was unmaintained and unkept, the cross-country skier or the cross-country walkers might expect that there could be a tree fallen in a wooded area, and that would not be surprising to them, and therefore they should expect to take that risk if they're entering. They might not expect to enter into a wooded area that's all covered with leaves, and beneath one section of that area to find a snake-filled pit. That would be an unexpected danger, right? And so if they fell in that pit and were injured as a result, then even though they were not invited onto the land, it's a danger that they never anticipated could be there. And so the landowner or the person in control of the property might actually be found then to be liable, probably would be, for injuries, okay? Otherwise, the licensee, the person entering the land, is expected to know that there might be common dangers for which the occupier would not be found liable. For example, those fallen trees in the woods or something along those lines. So what does the court ask? They say, would the reasonable licensee expect to encounter a particular danger? If not, then there is a duty of care. So if they did not expect to find a pit of snakes, a duty of care is owed. If there is a known danger, then no duty of care is owed. The licensee, therefore, is deemed to assume risk of known dangers, but not unknown dangers, okay? Then at the top of that pyramid, we move to the third category of entrant, which is an invitee. Essentially, that's anyone who is invited onto your property, okay? The presence of an invitee demands or expects or is linked to a mutual benefit, or at least a benefit to the occupier. So for example, a person shopping at a mall, there's a benefit, right, to both individuals there. The person entering the mall property is going to go buy something of interest to them. And the shopping mall also benefits because of the economy that's happening while they're there, right? The flow of money. A person who's visiting your home, you obviously have a personal interest in having them there, and there's mutual benefit there as well. So an invitee can be distinguished from a licensee. If you're ever wondering if you're ever struggling to identify what category someone might fall in, you can go to yourself and ask, is there a mutual benefit here? And if a mutual benefit is being enjoyed, or if at least the occupier is enjoying a benefit, then you can expect that that person falls into the class of entrants known as an invitee. Okay? And there is a higher duty owed to an invitee than a licensee. The invitee is at the very top of that pyramid. If an invitee is owed the duty to be protected from unusual dangers in the places he is allowed to go. So, what does this mean? If you say don't go into this hallway, but they do anyway, so you've told them not to because you know there are dangers lurking in that hallway, and they do anyway, then less of a duty is owed to them. In other words, you're going to be less liable as an occupier because you said don't go in there. But if no place is off limits and they're visiting your property, then they shouldn't expect any surprises. They should expect that it's all safe for them to attend, okay? If there is a door to nowhere upstairs, or perhaps you're building off a deck off the second level and you've already put the door in but haven't completed the deck, there needs to be a sign or a warning, a verbal warning to them. Don't open that door. Because if they open that door, they're going to expect it to go somewhere. They're not going to expect to fall to their death or fall to injury, right? And so the duty that's owed to an invitee is specifically around unusual dangers in the places that somebody is allowed to go, okay? And here's that distinction again between the invitee versus licensee. You see it on slide 15, and it just outlines for you that distinction between benefit. In a licensee relationship, or in the category of licensees, the licensee entering the property benefits. The cross-country skier gets to use the property. The political candidate gets to get their spiel out about why you should vote for them. A licensor does not benefit. So the occupier of the property does not benefit in any way. In an invited relationship, the invitee, as I've already given you a few examples, both the invitee and the invitor benefit. So I'm going to stop this right there, this video, and we're going to come back to some other discussions in the next one. Thanks.